That's all right.
Good afternoon. Ron Sangster for Defendant Appellant, Westfield Insurance Company. The issue in this case is actually Miller v. Auto Owners is the issue. This case is a classic textbook example of a wholly different judicial philosophy that was previously employed by this court when it comes to interpreting statutes and, for that matter, contracts that adopt the statutory language, contracts that mirror the statutory text. By way of background, I use the Miller v. Auto Owners case as a teaching tool at the no-fault course I teach at Cooley Law School. Professor Wayne Miller at Wayne State Law School has also used the Miller case as a teaching tool at his no-fault course at Wayne State Law School, where I'm a guest lecturer on this very topic. The issues presented in this appeal illustrate the inherent conflict between this court's previous employment of what I'm going to characterize as a policy-based mode or method of analyzing statutes versus what I believe is this court's most recent jurisprudence, which is a faithful adherence to and application of the actual statutory text that is utilized by the legislature. That's been this court's position for the past 16 years. Westfield asserts that the Miller case is wholly at odds with the actual, clear, and unambiguous statutory text utilized in Section 3106, subsection 1. It's at odds with this court's method of interpreting statutes that it has enunciated consistently for the past 16 years. As a result, we're asking this court to to grant the application for leave to appeal or otherwise issue a decision overruling Miller v. Auto Owners and returning the proper analysis of this issue to the language utilized by the legislature when it adopted the No-Fault Act some 40 years ago.
Even were I to agree with you that Miller was incorrectly decided, that's not the end of the inquiry.
Oh, absolutely not, Your Honor. I've got a whole
the
lot.
Robinson factors for considering the stare decisis questions, I'm at least impressed that while we have disparaged Miller several times in orders, etc., we've never expressly overruled it. Right. It's therefore still good law.
Yes.
And we have, despite more recent recognition that it doesn't seem to scour with the actual text, it is a self-cauterized opinion. It had the potential for being broader, but every subsequent time the court sort of looked at it, it says, that's limited to its own facts, we're not expanding it. First of all, do you agree that that's kind of the history of Miller in this court? The Miller factors talk about reliance issues. They talk about the ability, whether this is creating the arguably incorrect case is creating coercion. If it's, I'm sorry?
You said Miller factors.
I'm sorry, the Robinson factors.
Right.
Sorry. Whether it's causing difficulty of application.
Yes.
I'm having difficulty, even if it's wrong, I'm having difficulties in seeing how the Miller analysis gets us where you want us to be.
Sure. First of all, as this court has observed on numerous occasions, the citizens of the state look to the statute to guide their actions. Mm-hmm. Citizens includes insurance companies. Our policy language is based on the statutory text.
I noticed.
We've altered, or we have followed the statute. Our insurance policy says we do not provide for coverage for maintenance of a parked motor vehicle unless A, B, or C, and by stipulation.
So the insured has no reliance interest because their contract,
Yes.
Section 13 of the exclusions.
But don't you also underwrite on the basis of Miller?
I don't get into the
Contract
underwriting.
that follows the statute, and the case law per Miller says what it means something different than what's plainly stated. So don't you underwrite on the basis of Miller?
For many years, Your Honor, courts or the insurance companies probably underwrote based on the family member joyriding exception enunciated by this court in the plurality opinion in Priestman versus Meridian Mutual for many years, but that didn't stop this court from overruling the family member joyriding exception in Spectrum Health versus Farm Bureau.
But so your answer
Sure.
to Justice Zara is yes, you do, your contracts do reflect the law as we say the law is.
No, the contract reflects the statute.
I'm sorry, the contract reflects the statute, but you're, but
The actuaries take into consideration the
I'm
laws.
going to be honest with you. I've never gone to an underwriter at Westfield or any of my other clients and asked, what is the pro rata increase that you factored into your premiums based upon the court's decision in Miller versus Auto Owners and its holding that all maintenance injuries are compensable under 3105.
So you don't have any
But
basis.
good lawyers like yourself and Wayne Miller teach these things. Don't just teach students, you also teach the insurance companies, don't you?
We teach insurance companies how to apply the statute and how this court has interpreted the statute and how this court has routinely applied a cogent, coherent judicial philosophy to
Would you be shocked to learn
interpreting
that they've
statutes.
been underwriting on the basis of Miller?
I'm sorry?
You wouldn't be shocked to learn that insurance companies have been
Absolutely
underwriting
not.
on the basis of,
They-
you'd be
they-
shocked
they
if
may
you
or may
weren't,
not.
wouldn't you?
It depends on what is it, 50 cents per premium to factor in the cost of, I mean, this claim itself is just a $6,000 claim, but I'm familiar with maintenance injuries that have resulted in hundreds of thousands of dollars.
This all goes to the Robinson factors. That's
Right.
why we're talking.
That's where we're trying to figure
Right.
out how this, if even we concede it's wrongly decided, it seems self-contained, it's been here for 30 years, what Robinson factors compel us to look this decision and say, notwithstanding it's been around 30 years, notwithstanding nobody has any trouble applying it, it should be taken out?
A couple things. This court has indicated in Willer, in a concurring opinion authored by Justice Markman, that this court has consistently called into question the viability of Miller versus Auto Owners, going back to 1997 in the Puttkammer decision, 1998 in the McKenzie decision, and even after they've called into question. And therefore, there shouldn't be any reliance on it because the court
decision
has...
actually reaffirmed Miller in a footnote.
Yeah, it did.
Actually
It's
reaffirmed
not reaffirmed, it has... called into
We're not
question.
talking about that
Right.
decision.
But
Can I understand,
when you
too?
go, sure, when you go...
The concomitant to the recent discussion we've had about what your underwriting policies do, I assume that if Miller itself was to be reversed or nullified, your underwriting policies would then reflect that decision too, and if in fact the premiums attached to your insurance policy didn't do that, the premiums attached to the insurance policies of your competitors would do that by
Which caused the
reducing,
marketplace to
reducing
readjust.
premiums.
Yes.
So I will get some refund because I prepaid through the end of the year. I'm just saying, if you win,
Maybe a
I
couple
get
cents,
some refund.
maybe a little. There's a lot of decisions coming out of this court that have an impact on the ultimate premiums that are paid.
Of course.
And this could be one of them, and I hope it is. The other, when you talk about
Counsel,
reliance interest,
I want to, take a step back very quickly and just look to the validity of Miller. And I just have a question for you. When looking at the validity of Miller, when a car is going through maintenance, don't you put it in park?
agreed. I will stipulate that most, if not all, maintenance activities are performed on parked vehicles. If I could flip
But
it,
if I'm doing maintenance on my car,
sorry?
which thankfully I'm not, but if I'm doing maintenance on my car, don't I put the vehicle into park in order to do the maintenance? Isn't the car parked in order to do the maintenance?
I agree. Let me ask you
And
this.
isn't that what Miller says?
That's what Miller says.
And so
That-
why are you so focused on, why today is the day that you are coming in front of this court with this urgency to overturn Miller?
It's
What
not-
is about today that you're
Actually,
here?
it's my first time in front of you, Your Honor, arguing this particular issue. Okay? I was
This has
certain,
been a lifelong quest. You're just a newbie here.
I was before this court
Welcome to the
in
party.
2008. Okay? 2008, arguing Willow versus Titan Insurance Company, arguing the same point.
No, but
So
here's my
it's not an
question. Did
urgency.
any of those cases deal with maintenance?
Willer did.
Yeah.
Willer did.
And in what way?
Fern Willer was scraping the ice and snow off of her windshield. That's maintenance. I can see it was maintenance. She slipped and fell on the ice alongside of her vehicle. okay? This court ruled that she was not entitled to
That's a
benefits.
different
But
type
maintenance
of-
isn't critical
yeah.
to that. I mean, that might be coverable under 3106 anyway, right? I mean, that doesn't, you don't need maintenance in that example.
Actually, two justices said that it didn't even get to 3105. It was former Chief
But two
Justice
is
Taylor
less
and
than
Justice
four,
Young.
right? And isn't 4 like, I don't,
Because, in Willow, the vehicle is not the instrumentality of the injury, okay? Justice Markman said, we're going to go beyond that, joined by former Justice Corrigan, said, we're going to get beyond that because they could conclude, a trier of fact could conclude that it does fall within 3105, but now we've got to get to 3106. And there, Justice Markman and former Justice Corrigan said that you're not going to be, that Miller was wrongly decided, it is inconsistent with the statutory text.
But alas and alack, 2 is not 4.
Oh, I understand that, okay? And that's, I can do math. And
That's why he's here again.
I understand that entirely. In terms of the reliance interest, though, that you brought up, if I may quote from this court's decision in Page versus Sterling Heights about what is required for this reliance interest, okay? And this is on page 511 to 513. Quote, such reliance is only present where the prior decision has caused a large number of persons to attempt to conform their conduct to a certain norm. For example, where an entire class of individuals or businesses purchase insurance and another entire class does not in reliance on a decision by this court, this may be viewed as the sort of reliance that could cause practical real-world dislocations. There is a significant distinction between merely complying with precedent and affirmatively altering one's behavior in reliance on that precedent. Where there is mere compliance with precedent, the overruling of that precedent will not cause practical real-world dislocations, but where a great number of people affirmatively alter their behavior in reliance on precedent, the overruling of that precedent may cause practical real-world dislocations. Then this court went on to say, it cannot be seriously argued that Randall Page, the injured person in Page, positioned himself in reliance on Hagerman versus GenCorp Automotive, which was overruled by this court in Page. He, as indeed any injured employee might see, did not script his unfortunate injuries and illness with reference to Hagerman or any other decision of this court. In this case, Mr. Norman did not script his injuries in reliance on Miller. He did not alter his course of action.
That's a really important thing that you just said, and
Thank-
I want to go back to
unlike
that.
everything else you said.
If I may be so bold.
No, but that's a really critical thing that you just said, and I think that bears a question, if I may.
Sure.
And the question I would have for you, counsel, is, okay, so when we talk about reliance and we talk about the fact of what happened in this situation, I want to give you a question. So I want to ask you, what happens to a person who doesn't have health insurance, who is doing maintenance on their vehicle, and the vehicle falls upon them, and they are now a quadriplegic? So the question I have for you, counsel, is, really at this point, their benefits are covered, everything is covered for life. What happens to that person now under your scenario if we overturn Miller?
You've got to go to examine the 3 exceptions to the parked vehicle exclusion, 3106. Under your scenario that you gave me, which is Miller, he is
No,
not
we
gonna-
understand what's going to happen. I know what's going to happen to the person. I'm asking you to just tell me from a human perspective what is going to happen to that person.
He is not going to be able to recover no-fault benefits, just as if he had slipped and fell in a parking lot and or suffered any other type of injuries falling off a roof.
And so when you talk about claims, and you gave a policy argument in the beginning, the question I would have to you then, ultimately, if that person doesn't have health insurance, okay, who's going to bear that? Is that person is going to now fall, instead of your insurance company bearing it, it's going to now fall upon the state to do that, correct?
Just as if he had fallen off a roof and didn't have health insurance.
So
And was rendered quadriplegic.
this is a good windfall for you, because if we overturn Miller, then the citizens of Michigan have to bear this, not the insurance company, correct?
It is in keeping with the statutory language. This is what the legislature gave us. And that's what I was going to ask you, Justice Bernstein, when you said all maintenance is done on parked vehicles. I would agree with that. How do you effectuate the legislative intent clearly embodied in Section 3106, which says accidental bodily injury does not arise out of the ... maintenance ... of a parked vehicle as a motor vehicle? How do you effectuate that language, that legislative intent, under your scenario?
Well, because ultimately, I mean, this is an interesting
can't.
thing that you're asking this question. But it's a unique, I kind of like
Got
it.
him on his heels here. You're asking questions of the judge.
Well, I have to tell you, I kind of like this though, because it makes it more of a fun interaction.
I agree,
But I
Your
think
Honor.
that, I
You go.
think,
I agree.
but does Miller not codify that?
Well, yeah, what Miller said was, we're going to ignore 3106. We're going to ignore what the legislature told us.
Which is what everyone in the state is relying on currently, right
No
now.
one in the state is relying on that, because everyone's going to still fall off roofs, everyone's still going to maintain their vehicles, no one's going to order their life around
Lawyers
Miller.
are relying on it.
So I have a question about the Uniform Act, which I acknowledge, of course, is not the same language that we have in our act. And so I don't know that it would bear on a plain language analysis of our act. But I'm wondering if the fact that the Uniform Act pretty clearly covers maintenance should bear at all on the stare decisis
No.
review that we're doing now.
I respectfully disagree with that observation. This court has
I
made
didn't make an observation or even an assertion. I asked a question.
Yeah, I respectfully submit the answer is no. This court has made it clear, going back to the Spectrum Health versus Farm Bureau case, where this court overruled the family member joyriding exception, an opinion authored by Justice Zara, made it clear that we don't rely on the UMVARA when it comes to interpreting our No-Fault Act.
Well, I said that already.
Right, we
It
rely-
doesn't bear on the plain language. The question was, should it bear at all on the various factors under Robinson with respect to stare decisis review that we're doing now? In other words, I think you're positing that this would be as a big deal. It's a dramatic change from from the way that our legislature wanted to set this up. And it seems to me, at least, I don't know how widespread the Uniform Act is, but if it has any traction anywhere else, it would seem to me that this type of coverage is available in those other places. And that's kind of what I'm throwing on your lap.
Which it does not. Michigan is the only jurisdiction that has this type of really broad, beneficial No-Fault Act in cases that properly fall within its rubric. Because, again, we provide lifetime unlimited medical expenses. And it's my belief that by parked vehicles, by limiting the compensability of injuries arising from the maintenance of a parked vehicle only to those three statutorily enumerated exceptions, it is furthering the cost containment goals of the No-Fault Act, which, because we're the only jurisdiction that has lifetime unlimited benefits, there has to be some cost containment. And this is a way of doing it according to what the legislature gave us.
What will you do with all your free time if we overrule Miller?
I'll find other things to do.
Have to teach other subjects?
Actually, I enjoy what I do, Your Honor. I really do.
Well, what you're going to enjoy now is sitting down.
Thank you, Your Honor.
Thank you.
Good afternoon. Dick Hillary from the law firm of Miller Johnson. I represent Spectrum Health. I think I'd like to pivot a little bit and be more responsive to the kinds of inquiries that you were asking of Mr. Sangster, particularly with respect to the Robinson factors and stare decisis, and picking up upon your comment, Mr. Chief Justice, about how the Miller decision, from all appearances, seems to have been self-cauterizing. I like that expression. I wish I had thought about it. The response, as you heard from Mr. Sangster, was to reference the joyriding cases. And why I pivot a little bit, because I had some post-traumatic stress disorder. I argued the joyriding cases here a few years ago. And
I hope you're recovering.
I recovered, but it took some time. But I argued very hard in the joyriding cases that the Robinson factors should apply. And I even argued harder because it was unquestionably clear to me, at least, that in overruling this judicially created joyriding exception, you were changing the law going forward. That much was clear. The response I heard from the court, and which I respect, is no, Mr. Hillary, we aren't changing the law. We're bringing the law exactly where it has always been, as expressed by the words of our legislature. I did not get prospective application. The application was wholly retroactive. Justice Zara, you authored that opinion. And in thinking about that for days and nights, it occurred to me there was a line of inquiry I had from you, Mr. Chief Justice, about where are the outer boundaries of this joyriding exception, Mr. Hillary? It started with a family member living in the household. It was then extended to a cousin living on the property, and it seemed to have expanded. It was not self-cauterizing. In fact, when the joyriding exception was created, it only got larger, this exception, and I had to concede that. It was very difficult to put definition on the outer limits. That is not the case with Miller. Miller has been the law of this state for 35 years.
I agree that this, as opposed to the metastasizing joyriding rule that we made up, this seems more self-contained. But in this very case, the insureds could not have any reliance on Miller because their very own contract told them that a parked car, an injury from a parked car, would unlikely yield to coverage. So I'm trying to figure out, in applying the Robinson factors, their reliance, there's the turbulence, if the case is creating turbulence. Doesn't seem to be that there's any difficulty of applying the Miller rule. But in a self-governing republic, which we still purport to be, the people on the other side of this mall get to make the rules, not us. Not when we're dealing with legislation. So when there's a circumstance where it seems, and for the purpose of my argument, my question to you, but it has a point. If you believe that Miller was wrongfully decided and therefore distorts the work product of our counterparts in the legislature, if factors under Robinson are evenly balanced, where should this court fall? Should the people be able to look to their statutes and understand what their rights and obligations are, or should they have to carry one of you on our shoulders so you can say, no, statute says this, but the Supreme Court said something else?
Well, in answer to your question, this presumption, which I think is fair, that these insureds had reviewed their contract, had understood how it worked.
I assume they didn't review their contract. But
your comment is in response to Mr. Saxter's position. If that assumption holds and has any weight, you must assign equal weight to the proposition, which is the law of this state, that an insurance contract can not provide less benefits than the No-Fault Act provides. And the No-Fault Act on its text says what it says with respect to maintenance. And in 1981, the Miller Court said this is what that means. So that reliance interest, as abstract as it is, considering what I think you and I both know is the case, that these insurers did not review their contract.
The only one that really has reliance are lawyers on Miller.
Well, and insurance companies.
Yeah.
And I will point out, Justice Viviano and Justice Zara, you talked about underwriting and premiums collected for the last 35 years. This is found in Westfield's application for insurance. Application to this court for leave to appeal. It's on page Roman numeral 17. Westfield concedes that in this case, the Court of Appeals, the Circuit Court, sitting as an appellate court, and the District Court were bound by this court's decision in Miller.
You conceded that in the argument.
So the fact that these courts determined directly or indirectly that coverage was owed for this loss came as no surprise to Westfield. And I think we all know that to be the case, but the suggestion that it had amended its insurance contract at some point in time, and that therefore impacts the reliance interest.
I'm sorry, I don't understand what you just said.
Whether Westfield amended its insurance contract or didn't,
okay,
it knew when it issued this policy to these insureds that it was covering this loss.
I understand.
It's known for 35 years since Miller that this kind of loss has been covered. Every insurance company in the state has known this.
Well, but the question is whether this court should continue to impose upon the insureds the Miller premium that it created. Because if we are, by decision, creating an additional cost that the statute doesn't provide, that's an incremental increase. Which we assume the actuaries.
I would not disagree with that. Okay. And I think that's a factor that this court should and could consider in application of the Robinson factors. But in this case, unlike the joyriding case, I believe Robinson controls. It's 35 years of this. Now, I will also say...
So can I say something? I agree with you completely that Robinson is extraordinarily important here. And there's something that Robinson says, and it pertains not to one of its factors. This is not one of the... What I'm going to read pertains to something that is apart from its factors. But I would suggest it provides the backdrop against which each of the Robinson factors needs to be reviewed. It says, "It is to the words of the statute itself that a citizen first looks for guidance in directing his actions. This is the essence of the rule of law, to know in advance what the rules of society are. Thus, if the words of the statute are clear, the actor should be able to expect, that is, rely, that they will be carried out by all in society, including the courts. Should a court confound those legitimate citizen expectations by misreading or misconstruing a statute, it is then that court itself that has disrupted the reliance interest." That's not a factor. That is really kind of the premise, the starting point of all the factors that follow in that initial analysis. What do you think about that?
Well, I understand that pervades all of Robinson, and that all the factors are married to that general proposition. But I will also say, and we haven't talked about, I think we're all conceding that this court today, if it had Miller fresh for the first time, might reach a different outcome or apply a different analysis. This presumption is that Miller was wrongly decided. I would concede to the court that the analysis employed by Justice Levin in Miller may not comport with all of you. It might comport with some of you, but the result reached in Miller was the right result. For reasons briefed by the parties in Miller, there was a question in Miller, never addressed, and Justice Levin tells us why. He says, I don't want to go there. It's too nebulous whether this vehicle that was up on a hydraulic jack, immobilized, was a parked vehicle as contemplated by 3106 of the No-Fault Act. He passes on that nebulous question and then decides Miller in the way that he does. Miller then gives us this very simple, easy to understand, self-cauterized opinion that has not been, at least in my judgment, extended beyond these kinds of claims. Maintenance injuries are covered. Simple, easy. And the court 35 years ago, Justice Markman, said that's what 3105 and 3106 say and mean. They look to the words of the statute.
I think they said more nearly the policy and the fact that the exception is so small, it's got to mean that because of the policy justifications that were offered.
I agree.
The words don't say it.
The words don't say that. The words, as Justice Levin read them, was this exception swallows the coverage grant of 3105 for maintenance claims. Mm-hmm. And he said the legislature could not have intended that.
Because they're crazy.
Well, I don't think he used those words.
Well,
but I don't disagree with the court that was the analysis employed. But I'm simply pointing out to the court that there was That was not the argument advanced by either side in Miller. I pulled the briefs. Call me crazy. But I had to get them from the court's archives. The argument advanced by auto owners and Millers and counsel for Mr. Miller was purely textual. It was whether this vehicle was parked under the No-Fault Act. That is a question that this court has not added clarity to. I think even today, Justice Levin's comment that that's a very nebulous, difficult, potentially...
Well, wait, we don't have any question in this case that this car was parked.
I disagree. We presume, because Miller was the controlling law, that we never had to reach that issue.
What's the argument that Mr. Norman's car wasn't parked?
It was immobilized. The car was up on a jack with a tire removed and could not be operated.
Oh, I see.
A parked vehicle is a term of art under the parked means parked. It doesn't say standing. The legislature didn't say disabled. It said parked. Oh. Parked means something, and we haven't, this court, but I don't think we need to go there, because I think Justice Levin did not want to go there because of the complexity in resolving that particular question and the factual circumstances that may come into play. So he crafted a very simplistic, some might argue elegant, some might argue abomination.
I'll say simplistic.
But it's simplistic, it's easy to understand, it's pragmatic. There have been reliance interests on both sides of the equation. It's been the law for 35 years. It has not been overruled. I would ask you not to do so now. And if you do, then I would ask to go back, Justice Larson, and talk about that other issue, whether this vehicle was parked. Because that question was left unanswered. But I don't think you need to go there.
You've suggested also, I believe in your briefs, prospective application for what does prospective relief mean? That it doesn't apply to this case?
It doesn't apply to this case or any other case out there.
So this is an ex cathedra decision. We just sort of are throwing out an advisory opinion to the world. Just a moment. I know we did this in Pahusky. I think it's an outlier. I'm not even sure it's constitutional for this court to issue an opinion that is binding on no one currently. Do you think that's constitutional?
You've done it.
I know.
You've done it. I don't know who to call, but I rely upon your actions.
And we did it in Miller, too.
You did it, and it goes to the same reliance interests that are talked about in Robinson. And it goes to Justice Bernstein's hypothetical about the horribly injured individual who is receiving no-fault medical benefits as a result of a covered maintenance-related injury, that if this court were to say tomorrow that Levin got it wrong, we're righting the ship, and these claims aren't covered, that Mr. Sangster, it tells you that person would not have benefits anymore unless you give prospective relief. And so it goes to those reliance interests, fairness. Now, my claim...
Mr. Hiller,
yes.
We did it in Pahusky, as you know, in the context of a situation in which a certain class of individuals had been incentivized not to get insurance and were found in this case to be responsible for certain kinds of happenings being uninsured. The reliance interest in that case was totally at odds, 180 degrees from whatever reliance interest can be identified in the instant case.
Well, let's simply just focus on my client altogether for prospective application. And my role as counsel for a client who comes to me with a claim like this and says, Mr. Hillary, you are a provider PIP lawyer. Is this compensable under Michigan law? Of course it is. Miller says this. It hasn't been overruled. We go to the district court. We file a claim. Mr. Sangster stands up in open court and says, of course it is. I'm trying to get up to the Supreme Court again. I want to talk about this again with this esteemed group.
Well, of course, anytime the law is interpreted or misinterpreted, it's going to create that kind of reliance interest until the law is corrected.
That's the thing about adjudication. It's retroactive. That's what it is. Particular and retroactive legislation is prospective and uniform.
And what I would ask is to apply, because of the reliance interest and because of the fairness involved, I would, for the same reasons you've done before, I would give it prospective application if you're going to do this.
Thank you very much.
I'm out of time. Thank you.
I don't think we're done. Submitted, thank you. Call is concluded.